Well, hello there. Welcome back to another fun-filled episode where we examine the fun-filled delusions of Delete Lawz. So, when we last left our friend Delete Lawz, we had just examined docket number 101, his motion for leave to amend to file a second amended complaint. So, I probably should have discussed this at the time. I didn't. But things are a little confusing on this, which is why I want to. So, first, we need to look at Rule 15 of the Rules of Civil Procedure. So, Rule 15A is for amendments, basically amended complaints before trial. So, we have A1, which is amending as a matter of course. A party may amend its pleading once as a matter of course within either 21 days after serving their initial complaint or, well, pleading. This isn't just for complaints, but we're treating it for complaints here. So, or if the pleading is one to which a responsive pleading is required 21 days after service of a responsive pleading or 21 days after service of a motion under Rule 12B, E, or F, whichever is earlier. So we already have this matter of course amendment. That's the one where he switched it from a defamation complaint to a copyright infringement complaint. But A2, other amendments. In all other cases, a party amend its pleading only with the opposing party's written consent or the court's leave. The court should freely give leave when justice so requires. Now, I think that last clause is kind of important and has been missed in coverage. When justice so requires. So the judge should freely let him amend if justice requires. But if it would be futile to amend anyway, just say no. But if we go down to 15D, that concerns supplemental pleadings. And so on motion and reasonable notice, the court may, on just terms, permit a party to serve a supplemental pleading setting out any transaction, occurrence, or event that happened after the date of the pleading to be supplemented. The court may permit supplementation even though the original pleading is defective in stating a claim or defense. The court may order that the opposing party plead to the supplemental pleading within a specified time. So basically, an amended complaint is where you say, well, this is what I sued for, but I need to fix my pleadings. Supplemental is, well, I sued, and then they did something else. So I'm adding that to the already existing suit. So it may sound like a small difference, but it is a difference nonetheless. So why is that important? Well, let's go back to the docket. Like I said, docket number 101 says, first motion for leave to file second amended complaint by Jose Maria de Castro. But if we go to the actual filing, it's captioned motion for leave to file second supplement to the first amended complaint. So he's asking to file a supplemental complaint. And pursuant to Civil Procedure Rule 15D. That's supplemental. 15D. So and we know it's supplemental because he's complaining about Kate's use of the video where he doesn't know how to hammer a nail. So that's definitely a supplemental pleading. But it, and if you remember, I was a little pessimistic about him being granted leave. Now, I realized as soon as I finished, I was probably a little too pessimistic because he's so aggravating that sometimes, oof. But apparently the Judge Burroughs, who has the patience of a saint, clearly, her patience lasts about one filing longer than mine does. So her order the next day, plaintiff's motion for leave to file a second amended complaint pursuant to Rule 15D. So she's granted him leave to file a second amended complaint, which is 15A, well, 15A2, but pursuant to Rule 15D, which is supplemental. So which is it? But it's granted. So defendant's motion to dismiss, ECF's numbers 94 and 95, shall remain pending, and defendants need not refile their motions unless ordered to do so by the court. So that means, well, you've got your motions to dismiss. I'm going to put them in my top drawer. We're going to sit on them until the supplement or amendment or whatever the hell it is filed. But you may not need to do anything. They may suffice. I might dismiss it as soon as I get the supplement, but we'll see. And she'll let them know if they do need to. So defendants, nonetheless, may supplement their motions to respond to any new allegations included in plaintiff's second amended complaint if they believe the legal arguments need to be supplemented in response to the new complaint. Now, here's where we see she's lost her patience. Plaintiff is advised that any further motions for leave to amend his complaint will be subject to more exacting scrutiny. And then she tells him to file via ECF. So, more exacting scrutiny. That sounds like leave will no longer be freely given. You've got to come with a compelling case as to why because at some point it is a due process problem. The defendants need to know what they're defending. If it changes every week, they don't know. So that's fun. But now, because Delete Lawz is both a child and a tyrant, he's filed yesterday, at the time I'm recording, it'll be 2 days ago when the video's uploaded, but on January 16th, the second motion for contempt of court by Peter by Jose Maria de Castro. And I have a feeling at some point, and it could be this is the one that breaks Judge Burroughs' back as well. At some point, she's going to, at the very least, chastise him. You need to stop. This isn't contempt. This isn't even close to contempt. You need to stop. But let's take a look at it. So, plaintiff's second motion for contempt. Plaintiff Jose de Castro hereby moves this honorable court, which, remember his videos disparaging the court, but it's an honorable court when he wants something, on January 17th, 2023, or as soon as parties may be heard, for an order holding defendant Catherine Peter in contempt of court and ordering sanctions and such other further relief as this court deems proper and just under 18 U.S.C. Section 401 and this court's inherent supervisory powers. In support, I declare as follows. At ECF number 33, the court ordered, in part, plaintiff and defendants are ordered not to engage in any threatening, harassing, illegal, or otherwise inappropriate behavior when engaging with each other or with any individual or entity that may have knowledge pertaining to this matter. So, no threatening, harassing, illegal, or otherwise inappropriate behavior. Which, once we see what he's complaining about, it was none of those. But that's also when engaging with each other, making a video about him is not engaging with him. There was no order not to make videos, not to talk about him. But Delete Lawz is a tyrant, and he's trying to use the court to silence Kate in any way he can. There's no gentle way to say that. He is a tyrant, and he is using the power of the court, or at least trying to silence Kate. And I mean, right before starting this video, I saw Blue Bacon's community post where Delete Lawz is threatening to sue Blue Bacon because the process server showed up to serve him with notice of the restraining order, harassment prevention order, or whatever it's called there in Washington. He uses the power of the state however he sees fit, yet Blue Bacon using a process server to do a legitimate purpose, whether you agree with the restraining order or not, that's irrelevant. It's got to be served. And using a process server to do so is not harassment. It's ridiculous. I mean, it'll be laughed out of court. And besides which, how would he serve a lawsuit on Blue Bacon without serving process? So what's good for him is, not good for others, apparently. But this is just frustrating that Kate has to defend this nonsense. But continuing, at ECF number 43, the court ordered, in part, the parties are reminded of their obligation to comply with the court's order on October 21st, 2022, which forbids all parties from engaging in threatening, harassing, illegal, or otherwise inappropriate behavior with respect to other parties in this lawsuit. The parties are further advised that failure to adhere to the order may result in, among other possible sanctions, monetary fines. At some point, Kate just needs to actually do a dump on the court of all the deranged, unhinged, threatening, ranting videos that Delete Lawz has made, both about her and Josh, but also about the judge herself and Caitlin McManus, the court clerk. But continuing, at ECF number 51, the court ordered, in part, the court strongly recommends that the parties not harass, disparage, or otherwise act unkindly to each other. But that's a recommendation. That's not an order. She didn't order them not to disparage. She recommended. Or act unkindly to each other, or any potential witnesses in this matter. It is the suggestion of the court that, going forward, when faced with questions of conduct, all parties to this litigation and their associates hearken back to the lessons they learned in elementary school about getting along with others, proper behavior, and cooperation, and act in accord with those lessons, hopefully without constant recourse to the court. So that was the judge saying, cut it out. You don't need constant recourse from the court. Don't run to mama judge to fix all your problems. At some point, she is going to impose the cost of defending frivolous motions. And I think we're closer to that happening than to it not happening. Defendant Peter published a YouTube video that began streaming 2023, 1/12. Yeah. Basically, it was on the 12th of January, titled Regarding the End Torture Cuffs Deception Mark Stout Debacle. So that was her video, well, her live stream from a couple days ago, where she illustrated Delete Lawz End Torture Cuffs website. And what she did, apparently this is harassment deserving contempt of court. But what she did is she went to his website. She did reverse Google image searches for the images of bruised wrists, allegedly bruised wrists, that were submitted by people showing their injuries from torture cuffs. Except most of them were actually stock photos of eczema. Yeah. And the stories accompanying these were all written, at least the ones highlighted, the ones I've seen, they're all in Delete Lawz writing style. They're certainly all in the same writing style. I think in his writing style. But pointing that out apparently is harassment. So, continuing. I have copied this information from YouTube on January 16th, 2022, and this is a true and correct copy. A screenshot is at Exhibit 1. The screenshot shows Peter committing trade disparagement. Seriously, trade disparagement. Trade disparagement? Pointing out that pictures on a website already existed on other websites is trade disparagement. Okay. But it's trade disparagement against plaintiffs yet to be released, undisclosed technology launch in her YouTube video. Peter acquired the private URL of a web application product owned by Plaintiff DeCastro that is being developed and funded by DeCastro with a third party. The web application product is currently unfinished and undergoing beta testing. Although Peter knew that the website was not live, Peter stated, as fact, that the website was complete and disparaged the quality of the site in a video over 2 hours long. Like half an hour was about that. Most of the video was Mark Stout and then opened up to panelists that I switched it off once the panelists were up just because it gets too cluttered for my monkey brain to follow. Peter read several of the placeholder stories. Oh, they're placeholder stories. On the website and attempted to track down the source of the placeholder images and stated as fact that plaintiff was trying to pass these placeholder stories off as real in an attempt at deception with the most bullshit site, timestamp 318. Peter called plaintiff a liar. Yeah. You've been demonstrated to lie many times. Several times in the video, and said that plaintiff himself uploaded the images and typed up the stories in an act of deception to con, grift, and benefit from supporters. False allegations and outright slander. Ooh. This court ordered both plaintiff and defendant specifically not to defame each other. Peter has violated that order, matter of fact. Okay, why is it matter of fact? Then, after that, Peter and her associates then left comments and fake stories on the unpublished website. Okay. He says, Peter invited her followers to do this at timestamp 1446. This clearly violates this court's orders, since she literally stalks me on Discord. Oh, I thought he meant she goes to his Discord to stalk him, unlike him sending his spies into her Discord to, record the voice chat and... Yeah. But I don't think he knows what literally stalks means. But tracks my business operations and location and streams any videos I make on back channels so that Jose de Castro does not get the views on YouTube. This means that Peter knows that my future endeavor website is coming soon, that I'm not a web developer myself, and she obviously knew that the stories were also not real, but told 7,360 people so far that these beta testing stories and pictures were meant to deceive them with fraud, instead of obviously being placeholders for beta testing of layouts and features. Together with the ongoing and continual harassment that I disclosed to this court, Peter has shown that it is her intent to paint me in negative light, to harm me financially, and to inflict long-term emotional distress. To harm him financially. Where's that quote? I don't care if I win or lose. I only care that I cost her legal fees. Because I'm going to sue her over and over and over again until she's bankrupt. I'm paraphrasing there, but it's her intent to harm him financially? Yeah, right. But apparently that all puts her in contempt of this court. I know she has no plans on stopping any of the things she does to me without this court's interventions, because she is facing criminal charges in Boston for continuing to harass a woman, Doe, in contempt of court. Here I thought, last time he mentioned that she had already been convicted, according to him. But once again, I don't know Kate personally. I'm not an insider to this. But this is a woman who's friendly with Turtle Boy that Kate doesn't even interact with. But apparently her non-interaction is harassing. So, but Chili has no relationship with Doe other than she was also a target of Peter. Doe obtained a restraining order against Peter. You see, Peter cannot stop doing what she does because she runs an online troll mafia, harassment organization, that she heavily profits from and is her main source of income. I mean, she's got a full-time job, but okay. She has raked in almost $100,000 in the past few months alone from her trolling endeavors. The vast majority of that was specifically earmarked for legal fees to defend herself from your nonsense allegations. She wouldn't have raised $57,000 or $53,000 or whatever it is for a legal fund if you hadn't sued her. So maybe you're entitled to that $53,000 because she wouldn't have made it without you. Regardless, her unprovoked defamation and harassment, which I've ignored and not retaliated to publicly, the biggest bullshit comments yet, put her in contempt of this court. Finally, I remind this court that we are all in this court proceeding because these illegal acts went on for 6 months before I finally filed this litigation. I warned Peter that it would be costly if she persisted, and that I would persist through the legal system should she not cease and desist. And here we are today. Points and authorities. District courts have broad inherent power to enforce compliance with orders through civil contempt. Shilatani versus United States, Supreme Court, 1966. To support a finding of civil contempt, the evidence must establish: 1, there was a clear and unambiguous order of the court. 2, the party violated that order. United States versus Secaccia, First Circuit, 2005. Where, as here, all elements are clearly established by evidence, a finding of civil contempt is appropriate. Because the purpose of civil contempt proceedings is remedial, the defendant's intent in committing the contempt is not material. Citing Amger, which isn't law. So, and Exhibit 1, look at that. I mean, if I were beta testing a website, this is just an aside. If I were beta testing a website and didn't want to give the idea that I'm putting it up for fraudulent purposes, to deceive, I wouldn't search out pictures of bruised or marked wrists or whatever, most of which were psoriasis. I'd put pictures of, a generic Mickey Mouse or something, or even a picture that says beta testing or alpha testing because it's Delete Lawz. I wouldn't write fanfic stories for the captions. I'd put, this is a test. I'm testing this Torture Cuffs website, blah, blah, blah. It just, I'd want to make it clear that it's in testing. Now, assuming the website was unpublished, that leads me to ask, where did Kate get the URL? Did Delete Lawz try to set her up? I have questions, but at some point, if I'm Kate, I'm tired of every time I talk about Delete Lawz, he runs to the court trying to hold me in contempt. but he's allowed to talk about her all he wants. So at some point, my response is going to be, Delete Lawz is a tyrant trying to use this court to silence me in any and every way he can. Now, he can complain about that all he wants. Ooh, she called me a tyrant, I'm going to sue. But lucky for Kate, when she does that, if she ever does that, there's a thing called litigation privilege, where things written in litigation, in furtherance of litigation, generally can't be defamation, because the court has an interest in hearing all the facts and in hearing arguments and defenses, and him being a tyrant is a defense, at least to this. And I seriously think we're coming upon the point very quickly where the judge, this might be the last straw, and her response might be denied, cut it out, or else next time it's going to be the Uno reverse card and you're going to be sanctioned and hit with the costs of defending this. Because it's ridiculous. But Mr. Alpha just can't take anyone saying anything about him. I'm surprised, although I'm still obviously a small channel, I'm surprised I haven't seen my channel pop up in his videos. Maybe they have. I don't watch his videos. I see what other people cover of his videos. So if he has mentioned me, it hasn't been interesting enough for other people to cover. But he hasn't come to my comment section. So I could just not be on his radar yet. But yeah, it's just ridiculous. And with that, I think I told you, it would be a nice short one today after the 4-hour marathon discussing an even more delusional lawsuit last time. So with that, please like, share, subscribe, do all that fun stuff, and I will see you all soon. Have a great one. Bye-bye.